Hi everyone, Mufaro here, the Law Tutor SA, back again with another video. Today I want to talk about the law of evidence, the law of evidence module. This is one of the most practical subjects that you have, or most practical module that you have in your LLB curriculum, because it's very practical, especially for those that want to go into litigation. So for both criminal and civil matters, we need evidence, and the module touches on both criminal aspects and civil aspects. The most basic tip for going about this module is remembering or taking note of the fact that with everything that you're going to come across in the module, there is a general rule and then there are exceptions to the general rule. So everything that you study, there is a general rule and then there are exceptions. So I'm going to give random examples from the module to illustrate what I mean by the general rule and exceptions. Take, for example, oral evidence. If you're presenting oral evidence, we have examination in chief, where you call your witness, cross-examination when your opponent cross-examines them, and then re-examination where you try to do damage control. So with examination in chief, the general rule is that you cannot attack the credibility of your witness during examination in chief. That's a general rule. And then an exception to the general rule is if, for example, the person is a hostile witness. So they come on the stand, you call your witness, then all of a sudden they are turning on you. They start testifying in a way that is prejudicial or detrimental to your matter. Then you can have them declared a hostile witness, and in that moment, there is the exception. You can attack the credibility of your own witness if they are a hostile witness. Right? So you see, general rule, exception. Another example, random example, hearsay evidence. General rule is that we don't allow hearsay evidence, or hearsay evidence is inadmissible, if I'm to use proper legal terms. The general rule is that hearsay evidence is inadmissible, but we have exceptions when the court allows hearsay evidence. Also, documentary evidence, the general rule is that if we're using a copy, then the original document must be produced in court. It must also be there in court. Then the exceptions to the general rule, official documents are an exception. Another random example, character evidence. When we are dealing with character evidence, the general rule is that in a criminal trial, the prosecution is not supposed to bring up character evidence against the accused. So they cannot, for example, testify about his bad character, or, for example, bring about his past convictions in a way to try and convince the court that this person has done this before, so this time they are guilty. So as a general rule, the prosecution cannot bring up character evidence. But what is the exception? An exception would be if the accused himself or herself brings up character evidence. He or she starts testifying about how he has been rehabilitated, or how he's generally a person of good character and good morals. In that, there is an exception. The prosecution can then start cross-examining the accused on his character and also his past convictions. So those are just examples from the module, just to illustrate the fact that I said in the beginning, that when you're approaching this module, look at what evidence are you dealing with, what is the general rule, and what are the exceptions. And that's how you can best answer questions, especially scenario questions. You look at maybe the scenario describes one of the exceptions that exist, and then you know that you'll be able to use that kind of evidence. Until next time, bye.